Thank you, Madam Chair. I have a question or two in light of the recent public revelation that Senator Wyden referenced, that the NSA has been using a loophole in the FISA Amendments Act to search for Americans' private communications without a warrant, what some people have dubbed the backdoor search loophole. Now, I think it's fairly clear that the intent of Section 702 was to target foreign communications. But the government clearly, based on that letter, believes it has the authority to deliberately search for the phone calls or emails of specific Americans and to circumvent the traditional warrant protections guaranteed by the Fourth Amendment. I would ask Mr. Leggett and Mr. Cole, do you believe that the government should be allowed to conduct searches of information on U.S. citizens collected under Section 702 without having to seek a warrant for that information?
Senator, the way that it has been viewed and the courts have interpreted it is that the first issue is whether you are legally authorized to collect the information in the first place. This is what Section 702 allows us to do. We target only non-U.S. persons and only people believed to be outside of the United States. And those are the strict limits. Obviously, there will be communications that will involve Americans that are incidental. They're not the ones that are targeted. But we're allowed to collect that information.
So you end up collecting incidental information
That's
on
correct.
Americans, and you're saying that the authorization under Section 702 to collect that information trumps the protections that those Americans would typically be afforded under the Fourth Amendment?
It's a several-step process. You first are allowed to collect the information. It's just like a traditional criminal law wiretap. You have the person and the phone number that you have wiretapped, but you collect calls that they make to other people who may not be the target of your investigation, but you'll collect those calls as well because they involve the person whose phone you are tapping. So it's the same thing with 702. If you are legally permitted to collect that information, then you've got it. And then the question is whether or not we can access that information, use the information that we legally possess. And this is what is different from the warrant requirement, because the warrant is going to search for the Americans, the U.S. persons' records, which we're not doing. We get those incidentally, but we have them legally under 702. And then the question is whether or not it's then appropriate to look through those records, because they're already legally ours. We haven't made a violation. We haven't gone out to seek them illegally in any way, shape, or form. They are legally within our possession and control. To further legitimate criminal investigations, to further legitimate counterterrorism investigations, and things of that nature. And certainly, we have restrictions that we try to place internally on those. We try to make sure that they're used responsibly. We try to make sure that they're only used for specific purposes. But we already legally possess it. And it's just a question of not ignoring what we legally possess.
Mr. Cole, I think you've made the government's position very clear, and I appreciate that. I think it's something we should probably look at given the fact that we have this opportunity for reform right now. I want to get to my final question because we're running short on time already, but I want to go back to this issue that was raised early on in the questions around how H.R. 3361 defines a specific selection term. And in looking back at the old draft from the House, it said a term used to uniquely describe a person, entity, or account, end quote. It was a pretty tight definition. The new version says specific selection term means a discrete term such as, and then there's sort of a laundry list of items in there. I have a little bit of trepidation anytime I see such as, because then it's up to the person reading to decide whether the next thing they imagine is part of that such as or is not part of that such as list. Under your interpretation of this definition passed by the House, what are some records that would be excluded from collection under a specific selection term?
Well, I think any bulk collection, what is currently being authorized by the court of the collection of all telephony records and internet metadata records indiscriminately, that would be prohibited. That would be very clearly prohibited. Certainly if you went to collect all the telephone records within a certain zip code indiscriminately, that would be prohibited, because the point of this is to limit and to focus. It's to prohibit indiscriminate collection and only authorize focused and intentional collections for a specific purpose. The reason the such as is in there is that it's very difficult to predict unerringly what you may come across that you might need that will, for example, involve a larger number of records than just one specific telephone call to one specific person at one specific time. Some of the examples I gave in my opening statement. You have somebody who you know is going to build an improvised explosive device using ball bearings and fertilizer. You may want to go to the stores in that area that sell ball bearings and fertilizer. It's broader than just a single specific item, but it's much less than, every store in America regardless, and then sort through it. If you know a terrorist suspect stayed at a particular hotel for a couple of nights, but you don't know who it was, you might get that hotel's records for those couple of nights to see who all the residents were or all the guests were at the hotel, to be able to then cross-reference that with other information to identify who that terrorist was. Again, it's focused, it's discriminating, it's not indiscriminate, but it's larger than a specific identity of a single person. So we need to have enough room to do an investigation that will be effective, and we need to have enough restrictions so that we're not indiscriminately collecting records in bulk, and that's the means. If there are better ways to define it, it's a tough one to define.
Right.
But if there are better ways to define it, we're open to working on that.
Right.
We think this does it.
I appreciate that, and I appreciate your willingness to work on it. I think the chair brought up the issue early on in the discussion. I would just end by saying that I think we tend to get it right when we do a good job of defining the terms very specifically. I don't give a lot of trust to legislative intent and legislative history being the thing that describes, that ends up holding the day in court years from now. I think the words in the law hold a lot more sway at the end of the day in the courtroom. Thank you.